When it comes to felony DUI in Florida, the first thing that we do as criminal defense attorneys is ask, what were the aggravating circumstances that by law allowed for the state attorney to file this charge as a felony? And the two factual scenarios are significantly different from each other and raise interesting questions with regard to the culpability of the respective defendants. The most common way for an individual to be charged with felony DUI is by having multiple DUI convictions. Most people don't understand that the timelines are a bit tricky when it comes to evaluating how much time has elapsed between the arrests, resolutions of the cases, and seemingly violating the timetables that otherwise permit the filing of felony charges. Remember, when we talk about felony DUIs in South Florida, Broward County, and Palm Beach, we talk about cases that command incarceration by prison in most cases. This holds true even if the prior DUIs were seemingly spread out over the course of many years from one another. In the second scenario, where somebody becomes seriously injured or killed, and the defendant is alleged to have consumed alcohol or a controlled substance to the point that their faculties were impaired, or that they were just over the legal limit. These cases are difficult because in more cases than you would imagine, it is not the fault of the driver that was impaired or alleged to have been impaired that caused the harm. And although necessary in order to obtain a conviction, the fact that the charged defendant may not have been at fault is of no consequence where a state attorney is still proceeding with charges. I have said many times in the past, DUI can be very challenging when it comes to assigning blame as a society and truly understanding levels of criminal intent. I've used several factual scenarios over the years in order to explain this, and I think that this scratches the surface as well.